decision was good for you, and you didn't mention that the judges were appointed by Akufo-Addo. But then here, when you have a case against you and you mention that the judges were appointed by Akufo-Addo, trying to lead the people's minds to something that is undermining the authority of the judiciary, then you're a terrible politician, and we need to point it out. These are the judges. These are the judges who delivered the ruling in the Supreme Court 5 of Lord Chief Justice Gertrude Torkornoo, Justice Mariama Owusu, Justice Kwame Asiedu, Justice Yao Jewu, and Justice Yao Dako Asare. All 5 took the decision that the Speaker's decisions ought to be stayed. They didn't say much beyond that. They said it ought to be stayed until the final determination of the matter. We have looked at all the details, and tonight we're here ready to share something with you. But we also want to ask a question. We want to ask a question. The Speaker of Parliament. So the question we're asking tonight is this: has Speaker Bagbin failed the test of patriotism? Has Speaker Bagbin failed the test of patriotism? Now, how are we saying that? Speaker Bagbin came onto the Speaker position on the back of a Speaker who has been selected by the party that was not in government, and therefore we're going to have a tight parliament. I'm sure they will show the swearing in of Speaker Bagbin as I'm talking about this, since I want to bring it very graphic to you viewers. So this is how he came in, on the back of a Speaker who was not going to do the wrong bidding of the government and all of those things. This is the fateful day in the Parliament when the Right Honourable Speaker came to the Parliament, and he was decorated by the high-profile officials and the clerk, and Alban Sumanu Kingsford Bagbin pledged to do all rights to all manner of persons. Now, this is Mr. Bagbin taking his cloak on. Okay, get back to the studio. We have a long night. Let's leave that. Now, so I'm asking the question that, has Speaker Bagbin failed the patriotic test? Now, why am I asking this question? Speaker of Parliament was sort of invited by the minority leader to declare seats vacant, that he should declare seats vacant. And so he proceeded to do so. And then the majority complained about his decision to declare a seat vacant. They raised constitutional issues. He ignored it. And then they went to Supreme Court. And then the Supreme Court heard them in the preliminary case and decided that they have stayed the Speaker's ruling, or whatever interpretation he puts on the Constitution Article 97 and 99 has been stayed. They directed further that all 4 members of Parliament should be allowed back into the Parliament. This is the ruling of the court. The court has served the ruling of the Speaker. In the circumstances, the Speaker's decision is null and void. Now, the Speaker is not able to come to the chamber today and to say that, well, I took this position, the Supreme Court thinks otherwise, I'll move on. In the presentation that we'll do, viewers, tonight, I'll show you that when another Speaker, Justice D.F. Annan, when he was confronted with the same thing, he wrote a letter and indicated what speakers should be doing in that letter. He wrote to J.H. Mensah. I'm going to show the letter to you now. And then you will see that there has been a speaker before, and it is sad. When you look at a democracy that is growing, and you can find better examples in the historicity, and you can't find the better examples in the current. You look at the historicity of the Fourth Republic, you can find great examples, and you come forward, you can't find the examples. That is a democracy that is running on a dangerous ground. We should be finding the better examples as we go along, and we can be guided by the precedent. Speaker Bagbin did not allow himself to be guided by the precedent. They also often cite Professor Michael Quay. Michael Quay has spoken, and we're going to deal with all that tonight. So we have an interesting show tonight, but I'm just thinking that Speaker Bagbin may have failed the patriotism test. The story has come out today that in taking the decision, he had met with majority and minority leadership, and in the leadership situation, he had denied being part of the NDC's decision to sit on his left-hand side, which is where the majority sits, and that the clerk had not directed it, and that he was coming into the chamber, but he really did not get to the position where he's asking the NDC to do the right thing. Whilst he indicates that he's not with them, he didn't quite say they should come and do the right thing. He actually said that he wants to consult people. And so we are suggesting to Speaker Bagbin tonight that he may have failed his test of patriotism. Why do we say that? Here is the oath of the Speaker that we put on the touchscreen right now. And the Speaker always swears the oath to say, and I quote, that I will bear true faith and allegiance to the Republic of Ghana as by law established, that I will uphold the integrity of the Republic of Ghana, that I will faithfully and conscientiously discharge my duties as Speaker of Parliament, and that I would uphold, preserve, protect, and defend the Constitution of the Republic of Ghana, and that I will do right to all manner of persons in accordance with the Constitution of the Republic of Ghana and the laws and conventions of Parliament without fear or favor, affection, or ill will, so help me God. If you're a speaker and you take this oath, you take a position and the Supreme Court sends you a notice that whatever decision you took was wrong, and your reaction is not to be able to tell the minority immediately to do what is right, and your reaction is to adjourn sine die, well, then we think that you have failed the patriotic test. But we have a lot more to show tonight. I'm going to get my guy to come on the touch screen to sort of help me to do it. In the meantime, let's play It Is Raining for you to ginger you up as we are about to hit the road. I was just checking the time. We're about to hit the road really, really well. We'll get to Frank Ejechum and the Attorney General in a minute, but let's get the reaction. Let's get the reaction right now. Okay. Please give me It Is Raining, and let my guy come into the studio. Let's deal with it right now. Okay. Ride on Jesus, give us more rain until we are filled and we are so with the latter rain. It is raining all around me. I can feel it, the latter rain. Ride on Jesus, give us more rain until we are filled and we are so with the latter rain. Ride on Jesus, give us more rain until we are filled and we are so with the latter rain. Ride on Jesus, give us more rain until we are filled and we are so with the latter rain. Ride on Jesus, give us more rain until we are filled and we are so with the latter rain. It is raining all around me. I can feel it, the latter rain. Ride on Jesus, give us more rain until we are filled and we are so with the latter rain. It is raining all around me. I can feel it, the latter rain. Ride on Jesus, give us more rain until we are filled and we are so with the latter rain. Ride on Jesus, give us more rain until we are filled and we are so with the latter rain. Ride on Jesus, give us more rain until we are filled and we are so with the latter rain. Ride on Jesus, give us more rain until we are filled and we are so with the latter rain. It is raining all around me. I can feel it, the latter rain. Ride on Jesus, give us more rain until we are filled and we are so with the latter rain. It is raining all until we are filled and we are so with the latter rain. Ride on Jesus, give us more rain until we are filled and we are so with the latter rain. Ride on Jesus, give us more rain until we are filled and we are so with the latter rain. Ride on Jesus, give us more rain until we are filled and we are so with the latter rain. All right, we are ready now to deliver it. So I'd just like to tell you where we're going to start from. My producer, Lawyer Preku, and I will be doing this presentation together. So we're going to start from the UK Parliament. What happened in the UK Parliament? Why do we have cross carpet? And then we're going to pick the 1960 Ghana situation in 1960 all the way to 1979 Constitution, tell you what was available. And then we come to the 1992 Constitution where the articles are important. We get to the analysis, and then we'll talk about Ex parte Corsa, Ejechum, and then the Mike Okwe's ruling. What was the Mike Okwe's ruling about? The rules of interpretation, and then we'll come to our conclusion where we cast a verdict. Who was wrong, who was right? Stay tuned. That's happening right now on Good Evening Ghana. But now we do the Spotlight. What is a Spotlight? So the Spotlight is our new feature where we pull up the most interesting text messages on our flyer comments, and then we call it. We've been doing that already, but the young people have now categorized it this way. It's called the Spotlight. So on as many editions of Good Evening Ghana, we will be having the Spotlight. What's tonight's Spotlight is here. And it was our flyer that said that Speaker Bagbin beats a retreat in an effort to circumvent the Supreme Court's binding directives. He adjourns sitting indefinitely. But Article 1123 and Order 53 may halt the Speaker of Parliament, may halt the Speaker of the 8th Parliament tonight. Join us for the story, the backstory, and the legal aspects from the 1960 Constitution to the Supreme Court decision in Ejechum versus the Attorney General. Don't miss it. Tonight is the thesis, the antithesis, and the synthesis. Okay, here we go. Adai Elijah says, fire on the mountain today. Trust this man to give you intellectual analysis devoid of insults this evening on this matter. What happened in the chamber of Ghanaian Parliament is national shame. The chamber, which is supposed to be the arena of brainstorming, was reduced to march past chamber. Okay, there wasn't a showdown because MPs from the MPP side intelligently and wisely avoided it and saved our country from a worldly embarrassment. The MPs from the NDC side came to Parliament with gargantuan muscles and sat at the majority side. But the MPs from the MPP side came in with wisdom, maturity, and intelligence. Consequently, the smart walked out, and the wicked plots and plans of the NDC was botched subsequently. The handicapped Right Honorable Speaker Bagbin adjourned proceedings sine die. Alhassan Musa Ibrahim, you can be a great news reporter. I mean, the way you put it, you just reported it better, I'm sure, than some of the news networks today. Very, very good news reporting from Alhassan Musa Ibrahim. Train hard, you will be the best news reporter one day. Kennedy McDonald Okain says, I'm not surprised by the speaker's behavior, considering Honorable Muntaka's previous descriptions. In my opinion, he says, he's the worst speaker we've had, and someone of his stature should be well versed in parliamentary procedures. It's very pathetic. Engineer Gidath Kunaki says that, hello, Paul Adumoche. I appreciate it if you could bring an independent or neutral legal practitioner to give us the true analysis and explanation of all what it's about. Bringing partisan people for these types of analysis will not help. There's nobody in the studio, sorry. It's just us. It's just us. We have analysis for you, but it's not partisan. When we present it to you, you can decide what it is. But we know that our analysis are solid. It's not partisan at all. Yeah, it will cast a verdict. Yeah, of course. But it's not. It's very correct, cogent legal analysis, and we'll share with you. Okay. Nalaya Mensah says the majority did not descend into the gutters with the NDC. That was what they had wanted because they have no issues and campaign message. Now we are going back to issue-based. There were some media houses who were stirring up things. It didn't work as they hoped. Oh, I see. Which media house is that? Okay. Can't wait to watch a great personality like you, Paul, on the touchscreen with facts devoid of insult. Suleiman Brahma says there was no retreat. what the Honorable Speaker did, Suleimana Ibrahim says there was no retreat. What the Honorable Speaker did and achieved was the use of superior wisdom to skillfully navigate the attempted interference of the Supreme Court in the work of Parliament. Just wondering how does one retreat in order to circumvent? I can't think far. Okay, don't worry, Suleimana Ibrahim. Watch the show if you can. You understand where we are getting to. He says, in SMP, because of someone's desperation for power, every institution must be run down. Miss Remeka, okay, I beg to say, if you got the power, are you not going to work with these same institutions that you are running down today? Legislatures are now talking like class peoples. If you throw a ball against the wall, it surely comes back to you. Okay. By their fruits you shall know them. Paul, make sure you read my message. I've read it, Enoch. I've read it, and I've read all the vernacular as well, so everyone understands. Good evening to you, Enoch Osei. Franklin Azu Jr. says, I admire the speaker long before he became speaker, but this is not about position number 3, as he always said, as if Ghanaians don't already know. It's about good legacy, Mr. Speaker. Please, Mr. Speaker, where do you address your legal issues? I learned you've asked your lawyers to do some filing. Where are they going to do that? Let's respect all institutions in Ghana, especially the court. The Speaker had no choice but to abide by the Supreme Court directive. For the NDC MPs, they know the right thing, and they are putting on this ugly spectacle to please their disgruntled supporters, he says. Agnes Chiravira says, when people say Professor Okoye set a precedent for the Fomena case, they don't add that it was this very Bagbin who is going on about Okoye's ruling, who said at the time that Okoye's ruling was unconstitutional. Additionally, what they are in fact saying is that if a murderer or a thief is arraigned before the court, that criminal can say, because A murdered or stole, I also have the right to murder. In which law book is that myopic way of defense thinking espoused? Okay, Agnes, thank you very much. Maclove Ado Opon Mafo says, I know the Apostle Paul will go to the conundrum of the whole matter and educate his cherished viewers with facts and insightful touchscreen analysis. Very, very sure we are here on the matter, as we know that Speaker Bagbin has suspended Parliament indefinitely. Okay, let's take a couple of text messages and then we are ready for the roll. What has Bagbin done wrong? What did the Supreme Court do? What does the law say? What are the various angles? What is the NDC's position? What is the MPP's position? What ought to be the correct legal position? Let's see the text messages first. And we begin with who, Fatih? Antoinette first. Antoinette.
Thank you so much, Paul. Here are what our viewers are saying. Edward Dugbaza firstly says, the Supreme Court is supposed to be the conscience of every nation. Our Supreme Court should learn from advanced democracies and should stop taking sides. Ghana is slowly becoming a banana republic. We are tired of one-sided rulings. Now, Shifman Osei, all the way from Kumasi, says, I actually commend the NPP for taking the path of peace and walking out of Parliament today. The NDC should get it into their heads that we are not in the revolutionary era, so they should behave, and JM is never an alternative, he adds. Now, Nana Kofi Jomot says, all the way from Nkranza, he says, patriotic voices in the statement of the Speaker to vacate 4 seats in Parliament. On point 6, the Speaker stated categorically that the interpretation of the Constitution lies in the bosom of the Supreme Court. So then, why is the Speaker and the NDC MPs finding it difficult to accept what the Supreme Court said? It's very bad for our democracy. Bennett Danso says, Paul, kindly play Honorable Muntake's video where he described the Speaker of Parliament as a tyrant for the world to know who the Speaker is. In fact, he adds, I must say that the Speaker is indeed a tyrant and not patriotic, else he wouldn't have thrown the country into this needless chaos and tension. But in all this, I say that this too shall pass. Now, Baba Chairman, all the way from Tamale, says, I wonder why level-headed persons in the NDC inflict these excruciating pain to themselves and their support base. They know very well that what the Speaker is doing cannot stand the test of time. The Speaker has placed his personal and parochial interest first before the interest of the entire nation. He says he is a disappointment to the office of the Speaker. Now, Sami Boachi adds, coming from Osaman Kese, he says the Speaker's actions to declare 4 seats vacant without hearing the side of the parties is actually unconstitutional, and he has been the worst Speaker of Parliament we've had. He should have waited for the interpretation of the Supreme Court. Those who were expecting anything bad should bow their heads in shame. The NPP is an abiding political party, and they are on grounds to make everything possible for Dr. Bawumia. Now, Baba Chairman, also from Tamale, says the same courts that acquitted and discharged Dr. Atuforsen were praised by the same people are now castigating the same court and calling them names, all sorts of names. Now, lastly, Oluwan says, in all of this, I say that we should take off our political lenses and look at what is going on in Parliament with our patriotic eyes. You would see that a group of people who only support what favors them and not what the law says.
Edward Dugbaza. The Supreme Court are supposed to be the conscience of every nation. Our Supreme Court should learn from advanced democracies and should stop taking sides. Ghana is slowly becoming a banana republic. We are tired of one-sided rulings. From Bernard Kujem. As a Ghanaian in the diaspora, I feel ashamed by the shameful act of the Speaker of Parliament and his NDC MPs. Listening to some of the NDC MPs, I can only recommend that some of them should go back to school. Furthermore, if they really think their chances of winning the December elections, why would they start creating chaos and anarchy in Ghana? It's only a party that is on the verge of losing elections that try to create chaos and disorderliness in Ghana. It's now cast in stone that the NPP would win the December elections because every respectable and educated person will not admire NDC as a party. Back to you.
All right, thank you, Tara. So this is coming from Kwame Osei, and he says, Paul, I just heard Honorable Cynthia Morrison of Agona West and Kweja Asante have rescinded their decisions to go independent and are back to their party. It will now bring NPP to 137 members and NDC to 136. Does this affect either the Supreme Court ruling or Speaker Bagbin's rulings? Gastiman says, I was seriously ashamed of the minority NDC about their behavior in Parliament today. They were behaving like school children. Shifman Osei from Kumasi Atonso says, I recommend the NPP for taking their path of peace and walked out of the Parliament today. The NDC should get it into their heads that we are not in the revolutionary era, so they should behave. GM is never an alternative. Abdullahi, Minister from says, NPP, we have to learn a big lesson and put up more effort in place to win both presidential and parliamentary seats in the upcoming general election to prevent what we are witnessing currently in Parliament. Baba Chairman from Tamale says, indeed, the NDC always wants to achieve anything and everything with violence, but like the majority leader said, the NPP will use their brains to achieve what they desire. Bizinana Kwame says the NDC is frustrated about the defeat that awaits them as Dr. Bawumia is miraculously turning the tables in all their strongholds. Neokind from Casa says the NDC wants to find every means to make this government unpopular, but the NPP will not fall for this trap. And lastly, coming from Master Planner from Kintampo, says if the NDC wants majority in Parliament, they should go to the constituencies and work harder and earn it. We don't manufacture majority at the parliamentary house. Ghanaians are further up with their tricks and propaganda. 2024 elections is about policies and track records. Vote number 1 on the ballot box.
All righty. Thank you very much. And we're going to do this in about, okay, so we're challenging ourselves to be able to do this in 20 minutes so that when we put it on social media, it will be good. All right, great. So we start the analysis. What is the conversation here? The conversation is that the Parliament of Ghana in 2020's election voted in a novel way that has not, the people of Ghana voted in a novel way to create a parliament that had never happened. They created 137 members of the minority, or NDC, the two biggest, the duopoly, political duopoly is held by the MPP on the right and the NDC on the left. So the Ghanaians voted to create 137 members of the MPP parliament and 137 members of the NDC parliament. And then another seat was won by an MPP independent candidate in the person of the Honorable Isiama, who is now the second deputy speaker of parliament. Isiama agreed that he will sit with the MPP, and there's been a lot of chaos in the parliament since then. As a result of this close mark, the NDC that had accepted to be the minority group, they didn't quite accept it, but that's what had to happen. So, you know, Parliament started with NDC forcing themselves as the majority group, and that's what created the chaos that embarrassed the whole country that they were trying to create again today. You know, you can't do that as a politician. You can't. You can't go up in Parliament and do something that will deliberately embarrass the Republic because you know that this is wrong. So on the night of the sit, the NDC fought and said they were majority. 2 days later, every Ghanaian knew who was majority. So we've forgotten about that. Recently, NDC came up and said the electoral roll, the voters register, is forged. There has to be a forensic audit. They took the whole country on a demonstration. In the end, they went to electoral commission. They didn't have evidence to show what they had been saying. And that, again, is unpatriotic politics. You can't do politics like that. We're in an election year. You have to campaign. You have to tell the people what you want to do. You don't just always want to create chaos. Electoral Commission doesn't have the numbers because they've transferred 200 and something thousand. Every Ghanaian was worried. They went to Electoral Commission. Bring us your case. Zero. Now we've stopped hearing about forensic audit. They held press conferences and said Electoral Commission must do a forensic audit. Now they stopped talking about forensic audit. They are looking for something else to say. That's irresponsible politics. It's absolutely irresponsible politics. And everyone who is part of that must bow down their heads in shame. That if you want this republic, those of you who are Muslims, those who are Christians, you want this republic to succeed. You go to church on Sunday and come and behave this way. You know that the Electoral Commission hasn't done anything wrong. But you go and say that they need a forensic audit and say Ghanaians should go on a demonstration. And go on demonstration at how you took permission from the police, went on a demonstration, spent police resources to protect the demonstrators. It turned out that they had nothing to say. Now this morning, NDC go into the chamber and then they go and sit at the position where they know they are not supposed to be, hoping that they can invite a quarrel. They can invite a fight. So they go and do Galamsey demonstration. Tell the demonstrators that go and remove car key, go and do this, so that they are arrested, so that there's a fight, so that there's chaos, so that the government doesn't work, so that nobody is asking about their message. No, God doesn't like that. And because the people of Ghana are praying, God doesn't like that. Anything you foment will be quietened. Within 48 hours is dead. So you started TUC is dead. Now where's your message? And the only message we had was that guns like Kenke and the Kenke cannot be digitalized. So that was a message. That came in between that week after the TUC issue died. That was the message. Anytime you try to pick a message, you see that the messages that they are putting out are ridiculous. And that is what is their worry. They are afraid that they don't have a message and therefore foment trouble. That cannot be patriotism. That cannot be in the interest of the unborn Ghanaians. That cannot be in the interest of the Ghanaians who are below 10 years old. They have a future, and we must have politicians who are thinking about the future of that 9-year-old government, that 10-year-old boy. That's why Akufo-Addo said, I'm more focused on the future of the Ghanaian than the next election. And that's why he does the things that he does. That's why he paid for the school fees. Anyway, let's move on. So, floor crossing or carpet crossing is a principle that occurs in the British Parliament. So this is the British Parliament. The middle here is the Speaker's position. The right-hand side of the Speaker, which is to the left of your screen, is the majority. And so you see the dispatch box here. That's where the Prime Minister speaks from. And those of you students, anytime you go to London, ask to visit Westminster, and they will take you around and they will show you everything here. There's some of the gold in this Parliament was taken from Ghana, and I've been to the Parliament before, and they'll show you, if you are from Ghana, this is the gold that came from Ghana. Sometimes when you see it, you just want to take it back and bring it to the country, but you can't do that because, you know, rules okay. All right, so the Speaker sits in the middle, the majority sits to his right, and the minority to his left. So the simple issue of crossing carpet, now, the carpet they talk about is this carpet here. This carpet here. This is, when they say crossing carpet, the carpet that is in the aisle between the majority and the minority. So this is an old concept, dating 600 years ago. So a person is sitting here on the side of the minority to the Speaker. He walks down this aisle, crosses here, moves here, sits here, he's cross carpet. He's cross carpet. And so he will now be counted on the side of the the side where he has sat. If you came from minority to the majority, you'll be counted amongst them. This is a principle in the British Parliament, okay? In the British Parliament itself, it's been discussed across many divisions. So also this is the principle that we talked about. Now you have Edmund Burke here. Edmund Burke is one of the advocates who says that the member of parliament is elected on his own, as Paul Adumotri. He's not elected because of a party. Whether he's on a party's ticket or not is irrelevant. Others argue against Burke and say that why then do they say that you are of Conservative Party, you are of Labour, you are MPP, and say another person is independent? If you want to go to parliament without a political party, you are entitled to do so, to go as an independent candidate. Why don't, so that those who challenge Edmund Burke make this argument. So in political legal philosophy, it is still being discussed what works. And constitutions from the different jurisdictions give a different verdict on what it is. So as far as the British Parliament is concerned, you can always cross carpet and there's absolutely no problem with it. In British Parliament, you can cross carpet and there's no problem. You can leave Conservative and join Labour. You can leave Labour and join Conservative. There's no problem with it. I'll show you examples of that as we move on very quickly. So here's Winston Churchill, the famous Prime Minister of the Second World War, the one who won it for England and won it for the free world. There's always been my verdict that it was Churchill who won it. Others think that it was Roosevelt. Others think it was Mussolini because he left Russia and he left the Germans and left the Germans open. Others think that it was Vladimir Lenin, etc., etc. But I believe that it was Churchill's decisions that made the Second World War successful to the Allies. That's a conversation for another day. But let's come back to Churchill. Okay, so Churchill then, where is it? Churchill he moved from one party to the other. Do I have it? Have I lost it? I have a slide that shows Winston Churchill moving from his party, the Labour, to join the Lib Dems, and then came back to the Labour Party. Is it further forward? Let me just check. I see the Ghanaian list here. Oh, no. If you can find a producer, if you can give it to me, it's very important. So I wanted to show you that Winston Churchill himself, who left his political party Conservative, joined the Lib Dems and rejoined as a Conservative again, and he was Prime Minister twice. He was Prime Minister during the war. He lost the position and came back. But he left to one party and came back to his party later. So in the British Parliament, this is altogether very good. Now, the Ghanaian Parliament of 1957 and the British Parliament had very similar rules. So between 1957 and 1960, in Ghana, it was okay to cross carpet and it would be fine. And I'll show you examples of people who did and some of the names that are interesting. So you have the famous MPP juggernaut, C.K. Tadem, who was with the UNC. His name is Kassina Nankana North. That's his constituency. Kassina Nankana North. That's C.K. Tadem. You have J.A. Brymer in the middle from Gonja East. And guess who? Who is there? Mumuni Bawumia, Muhammadu Bawumia's father. He was from South Mamprusi West. They all left their party and joined the CPP, crossing carpets in Ghana's parliament between 1957 and 1960. And also Yakubu Tali, he was in Dagomba South. He also crossed carpet and joined the CPP. So that was in Ghana's 1960 parliament. So this was the arrangement of the parliament. At the beginning, the parliament looked like this. In 1956, CPP 71, NLM, Balfour Sakoto's Party 12, MAP 1, Independent 2, the Northern People's Party, the MPP 15, TC 2 and FY 1. So, but by the time it came to 1960, because of cross-carpeting situations, the distribution had markedly changed. I have to say, though, that these groups of parties, some of them were banned by a new law called the Avoidance of Discrimination Act. Now, Kwame Nkrumah was worried that you can't have a political party and call it the Northern People's Party. The Ghana People's Party, I'm not sure whether it's TC or it's FY. But there was Northern People's Party, there was NLM, which was thought to be Ashanti Party because of the objectives of the political party. The objective as outlined by the NLM said that they were Ashanti Party and they were in the interest of Ashanti cocoa farmers. The attributes, the details attributed to the NPP by themselves, the Northern People's Party, that they were a Northern Party and they wanted their Northern assistance, etc., etc. The Parliament of CPP 71 passed the law called the Avoidance of Discrimination Act, and that all political parties who were set up as a sectional expression should be banned, and that law was passed sometime around 1959, and that's what brought the United Party. So all of these parties, NLM, MAP, Independent, NPP, TCFY, formed the United Parties. Now, so this was the distribution of the parliament, 71 here, 12, all that. But look at what happened. After the chickens came home to roost, and after the UP had been created, UP had by 1960 reduced to 16 from whatever number they had, and the CPP reduced to 16 from 32. When they put the amalgamations together, the United Party became 16. That was 12 plus 15 plus, they became 32, sorry. 12 plus 16 plus 1 plus something. They became 32. By the time the cross-carpeting happened, and by the time some of them had left the country because of the circumstance of the time, that's a story for another day, they had come to up to 16 from 32, and the United and the Convention People's Party had come from 72 to 88. So that was allowed in the Ghanaian parliament. Now, this is where the problem starts in the Ghanaian parliament as we move on. So because of the experience here in the Ghanaian parliament, original thinking began to come into the minds of our constitutional framers. Because there was such an alacrity for MPs to leave their party and go to CPP, because CPP is where the largesse was, Nkrumah had become dictatorial. If you were not a CPP member, you are in trouble. You either have to leave the country or join the CPP. Because that mischief was to be cured, when we came to the 1969 constitution, just before then, 1957 to 1960, this was the arrangements of the leadership of parliament. Kwame Nkrumah was the prime minister, therefore the majority leader. Queen Elizabeth was the head of state, and Prime Minister Abrifo Busia was the leader of the minority leading the United Party. It has to be said that Abrifo Busia also ran away from the parliament before it was too late. So that's 1957 to 1960. Now, in 1960, Kwame Nkrumah was president, nothing much to say about that. Then in 1969, the constitution decided that they were going to deal with this mischief where people were crossing carpet to the CPP, and they were going to depart from the British parliamentary provision, which allowed crossing carpet. In 1969, the framers of the constitution decided that Ghana was going to depart from that in this way, and I'll show you. So the leadership of the 1969 parliament was as follows. Afro Gbedema here to my right was the minority leader until he exited parliament for some legal issues. Edward Akufo-Addo, President Akufo-Addo's father, was the president, the head of state, and Prime Minister Kofi Buzia was the prime minister and the majority leader. This is the record of 1969. So it was in this parliament, led by Akufo-Addo and others in the Consultative Assembly, that decided that even though Ghana was practicing a Westminster system, they were going to put out a clause that will indicate a marked departure from the British principle of crossing carpets, which was allowed. And what did they do? Let's see what happened over here. Okay, so in that constitution, you have Article 75 2G of the 1969 Constitution, which says as follows. A member of the National Assembly shall vacate his seat in the Assembly, G, if, among other things, G, if he leaves the party of which he was a member at the time of his election to the National Assembly to join another party. So this is the first introduction in Ghana's political history of the clause that we are now dealing with, which is creating the issues today. This was in Article 75(2) of the Republican Constitution 1969. And it says, the Second Republican Constitution says that a member of Parliament, a member of the National Assembly, that's what they call Parliament then, the National Assembly. A member of the National Assembly shall vacate his seat in the Assembly, G, if he leaves the party of which he was a member at the time of his election to the National Assembly to join another party. You will recognize that in here, there's no mention of independent candidates, isn't it? There's no mention of independent. The Constitution of 1969 said that if a person leaves his party to join another party, now this was so because the framers of the Constitution were thinking opposite Edmund Burke. Edmund Burke held the view that it's about the individual, and the other view was that it's not about the individual, it's about the party. The framers of the 1969 Constitution held the view that it was about the party, so that if you are elected as a member of parliament for the Progress Party, say Kofi Abrifo Buzia was elected on the Progress Party ticket for Wenchi, and then he became member of parliament, and he decides that he's leaving the Progress Party to join the New Alliance of Liberals of Afro Gbedema. The people of Wenchi did not vote for the New Alliance of Liberals to occupy the Wenchi seat. They voted for the Progress Party. That's the philosophy in the position that is against Edmund Burke. That the people who cast their vote, they cast their votes on the symbol of a party, the colors of a party. Yes, the individual was part of it, but you can't take the party out. And therefore, they decided that, look, if you are voted on the ticket of the CPP, the New Alliance of Liberals, the United Party, and you come to Parliament, and then you move from one seat to the other, sorry, you can't do that. There's a by-election that has been occasioned, and you have to walk out of Parliament. You can file the by-election and come as somebody, and then come into the Parliament. So this was 1969. 1979, what did we have? And we're getting closer to 82, isn't it? President, of course, Hilary Mann in 1979. And this was here. Article 79I, 1979 Constitution. A member of Parliament shall vacate his seat in Parliament if he leaves the party of which he was a member at the time of his election to Parliament to join another party. You can tell that the difference in the Article 75 of 69 and Article 79 of 79 was just the change of the word National Assembly to the word Parliament, and it was repeated here. Here again, in the 1979 Constitution, still, we are not talking about independent candidates. We're not talking about an independent candidate becoming a member of Parliament or a member of Parliament becoming an independent candidate. What is precluded by this Constitution here, or frowned upon, if you like, is that you cannot leave your party, the party on which you were elected, to join another party. Now, we got an example of this, which Professor Ivan Adai-Mensah wrote in the autobiography for Dr. Limann. Adai-Mensah isolates two people, actually, who actually left in 79, their party, to remain as independent candidates. Now, the 69 and the 79 provisions did not preclude a person leaving to become an independent candidate. So, sorry, viewers, don't get frustrated. I'm getting to the point. I just want to build the historical fact and the historical foundation so that we can come in, and I'm sure you're expecting this, so let's get it done. We'll finish very soon, 10:15, don't worry. We'll finish on time. All right, so this is Adai-Mensah speaking as an authority of the 79 process, writing in Limann, in a book that he wrote for Dr. Limann, who was the president of the time. He indicates an example where two persons left their party and became independent candidates. Two actually very prominent names of the Third Republican Constitution. Let's see it now. Okay, now he writes in the book, the most contentious measures that were considered to be burdensome were the introduction of the hospital fees and the air travel tickets. Interestingly, these two taxes or fees are now standard components of our country's revenue mobilization strategies. Okay, let's move on. The debate on the budget, and that's the important part, maybe we should have cut this part off. The debate on the budget was very lively. It was during that debate that on the 22nd of July 1981, Mr. Kweku Baa, member for Nkoko, caused a major sensation in Parliament. Initially, contrary to popular belief, Mr. Baa at the time was an independent member. This is interesting. So Professor Adai-Mensah is right. He says that he's writing something that happened on the 22nd of July 1981. And he says that Mr. Baa at the time was an independent member of Parliament. He says, contrary to popular belief. So what was the popular belief? Let's get on. He said he, Kweku Baa, and Mr. Owusu Champong, member of Parliament for Brekum, had been expelled from the Popular Front Party, PFP, for challenging the leadership of Victor Owusu and taking issue with his leadership style. They had subsequently lost a court action seeking the court to declare their expulsion as null and void. In effect, J.H. Owusu Champong and Kweku Baa had both been expelled by the party that brought them to the Third Republican Parliament, the Popular Front Party of Victor Owusu, because they were disagreeing with Victor Owusu. But the provision here says that a member shall vacate his seat only if he leaves his party to join another party. So if he leaves his party to be in Parliament as an independent candidate, he doesn't lose his seat at all. That was 1979 provision and 1969 provision. We are building up to the end now. Okay, where are we getting? Let's now get to 1992 and look at the articles, and I'll be calling my producer in very shortly. 1992 is coming up now. So this is where we are now on the facts of the matter. We are getting into the Speaker Bagbin situation. Thank you. 1992. Okay. 1992, Article 79 1G of the 1992 Constitution. A member of Parliament shall vacate his seat if he leaves the party of which he was a member at the time of his election to Parliament to join another party, or seeks to remain in Parliament as an independent member. It says, if he leaves the party on which he was a member at the time of his election to Parliament to join another party or seeks to remain in Parliament as an independent candidate. Okay, so this is the position that the Speaker and majority of the NDC take. That this article seems to be very clear, and that's 97. I'll be coming to 99 in a minute. They think this article is very clear in that it indicates clearly that if a member of Parliament has left his party to join another party, or he wants to be independent, the law says that he shall vacate his seat in Parliament, isn't it? So they are saying that, okay, so you've left one party to join another party. Vacate your seat in Parliament. But is that all what the law says? What about this one? He says, if he seeks to join another party or seeks to remain in Parliament. So which Parliament are they talking about? Is it simpliciter that if a person leaves the Parliament, he leaves the party, just simple as that, the seat is vacant? Which Parliament are they talking about? If he wants to remain in Parliament, so we have first Parliament, second Parliament, third Parliament. This one is the 8th Parliament we are dealing with. A person has left his party to remain in the 8th Parliament on another party's tickets. Is that even possible, to leave your party and remain under the Constitution? It's not possible, because if you leave your party, the party will write to the Speaker and say that this person has left the party. And therefore, the Speaker will be told that the person has left the party, so he's not a member anymore. We don't know about his being in Parliament. Immediately, the Speaker says that your people say that you are not there, so you have to go. That's when the political party has written to the Speaker. And that was the case in Mike Oquaye, as we have been looking at. Mike Oquaye's case, the Speaker, the party wrote. Okay, so how is that different from right now? And I'm going to show you a few things. First, let's go to 99, though. Will I find 99 when I wrote? Great. This Article 99. A high court shall have jurisdiction to hear and determine any question whether A person has been validly elected as a member of Parliament, or the seat of a member of Parliament has become vacant. So who makes the determination about the seat of a member of Parliament? We will do all of that. We're just looking at it. The Supreme Court has said something, Mr. Bagme has said something, but let's look at it. Who then? Whose responsibility then it is to make the determination that a seat is vacant? Let's go back to 97. 97 says, a member of Parliament shall vacate his seat in Parliament if he leaves the party of which he was a member at the time of his election to Parliament to join another party or seeks to remain in Parliament as an independent member of Parliament. It stands to reason in other clauses that if you're an independent member of Parliament and you want to join a party, again, you have been found foul of the situation. So the law says he shall vacate. They say that when they say shall, it means compulsory. So it behooves on the member of Parliament to vacate his seat if so and so happens. If the member of Parliament does not vacate his seat, he decides that I won't vacate my seat. I've left the party, but I won't vacate. The seat is for me. I won't vacate. What does the law say in the circumstance? If, on the other hand, other people, members of Parliament, point to the Speaker that, hey, Speaker, this man has left his party, he's still sitting here. Should we carry the chair and throw him away? Whose decision is it? Who makes that decision? When a member of Parliament has so-called left the party that he came into, he's left the party, who makes that decision? He said that the person shall vacate his seat. So the person is one of those who makes that decision. The individual who has left, he can make that decision that, Mr. Speaker, I have vacated my seat because I have left the MPP. So, Mr. Speaker, I'm done. Here's my letter. I, so, Sam George Nate, I write from Pram. Mr. Speaker, I have left the National Democratic Congress. I have joined the Convention People's Party because Kwame Nkrumah is my hero. I prefer Kwame Nkrumah to John Mahama, etc., etc., etc. And then Sam George will go and put the letter there. That will satisfy I. He is vacating his seat and he's telling the Speaker that. In case he decides not to do that, or he is unwilling to do that, whose responsibility is it to get him to do that? And that's what you find in 99. The High Court shall have jurisdiction to hear and determine any question. When the question arises, the man has vacated his seat. Can he remain in the seat? That's a question that has arisen. And the law says that any question, to determine any question, the High Court shall have jurisdiction. A person has been validly elected to Parliament, or that the seat of a member of Parliament has become vacant. Is it coming around? The viewers, is it getting better? So this is what the law says. That yes, they provide the basis on which a situation arises. They provide a basis on which a seat is vacant. The law has provided that situation. How do you enforce that situation? The law always does that. The law always applies in 2 or 3 forms. First, they describe the situation, and then they also describe the enforcement. And that is why when the High Court or any court of the Superior Court of Judicature give a ruling, they always have what they call consequential orders of the court, consequent upon the ruling. So the ruling is given, and then the court will give the consequential orders of the court. So the ruling that was given against Peter Bagbin, for instance, that he should stay whatever he said, the consequential orders was that he should hereby permit the 4 MPs to attend Parliament. That's the consequential order on the Speaker. So it's the same way with the law. They provide the basis for it, and then they tell you the implementation authority. So the law has provided the circumstances under which a member of Parliament becomes vacant. And then the law has said that it is for the High Court to make that determination. Not any other person. Not any other person. It's the High Court to make that determination. Apart from the person who is involved himself, the next is the High Court. But we are building it. We are not done yet, viewers. We are still building it. Okay. So that's 92. We've talked about Professor Michael Quay, isn't it? Now, Professor Michael Quay said that a letter had been written to him. A letter had been written to him by the NPP, said that this man is not a member of our party. Now, the remain in Parliament is also an important matter. The remain in Parliament suggests that the framers of the Constitution were not thinking in this instance about a Parliament yet to be formed. So people who are leaving the 8th Parliament want to remain in the 8th Parliament as independent candidates. That is to say, those who are crossing carpets, those who are moving from here to go and sit here, wanting to be counted as that, like the British Parliament we talked about. It is them that the Constitution is precluding, because the situation that has happened today, those people who are being said to be leaving their party and living independent, they are not doing that for the 8th Parliament. They are doing that in anticipation of the 9th Parliament. So the clause here says that if a person joins to remain in Parliament, so as it is, the situation has not arisen for Speaker Bagbin to take any decision. Because the constitutional article is clear that it is for those who want to remain in Parliament. Speaker Bagbin has absolutely no jurisdiction over the 9th Parliament. He doesn't. Do you get my point, viewers? Speaker Bagbin is not presiding over the 9th Parliament. He's presiding over the 8th Parliament. The people that are being discussed, are they evincing an intention to remain in Parliament on a different party ticket? Is that what they are doing? If that's what they are doing, then the law is against them. They cannot remain in Parliament on a different party ticket. But they are anticipating that they will be in another party ticket in the next Parliament. In the meantime, they have an excellent relationship with the parties that elected them today. As far as the rest of this Parliament is concerned, for the few 6 weeks or 5 weeks left of the Parliament, those individuals do not have any problem with the party that elected them. They do not seek to leave the party that elected them to remain in Parliament. They are announcing to the world that in the future Parliament, I would like to be independent. In the future Parliament, I would like to sit with NDC. I would like to rejoin MPP, but it's for the constituents to decide on December 7th. The constituents will make that decision. Cynthia Morrison is evincing an intention that in the 9th Parliament, I want to be an independent candidate. So she's going back to her constituents and says that I don't want to be MPP anymore. I want to be an independent candidate. That will let me serve you better. Vote for me. Speaker Bagbin has no jurisdiction over the 9th Parliament of the 4th Republic. That's the story. But we are not done yet. That's the story. But we are not done. So this is the situation. If you look at this article closely, you will see that there's a remain in Parliament. Remain is there. So the people are not saying they want to remain in the 8th Parliament as independent, 8th Parliament as MPP or NDC. No, they say that for the 9th Parliament. And why are they saying that now? Why are they telling us that now? They are telling us that now because the administrative processes for the purpose of December 7th starts during the period of the 8th Parliament and start during the period of the incumbent's presidential term. Why am I saying that? In Britain, it's different, okay? every election in Britain, I'm using Britain because the home of parliamentary politics. Every election in Britain is the filing of the process happens after Parliament has been dissolved. So Parliament is always dissolved in Britain before they go and file their processes. They don't file it whilst the Parliament is still in office. Unlike ours, whereby administrative processes, we have to file it. So the people who are filing, they are talking about the next Parliament. They are not talking about this Parliament. That's the first point. Okay, let's move on. Let me now invite Apriku to come in and let's get some analysis. Do you have your microphone on?
Yes.
Okay, great. You look nice in suit all the time. The judges tell you that when you go to court.
No, I wear a gown. So.
Okay. So now let's look at the rules of interpretation. And that's what he's here to guide us with. The rules of interpretation. Okay. Now, first of all, let's take this one.
Okay.
We'll take this one before we come to the rules of interpretation. Now, the reason why he's put this here is that way back in 1980, we found out, way back in 1980, there was an issue about when does the Supreme Court's power of interpretation, do you have Article 138, the Supreme Court's power of interpretation? Yes.
Article 2.
You want us to use 2?
Yes, that's
there's
they have
2.
The power to interpret and enforce.
They shall have the exclusive.
Exclusive.
Okay, please bring me a
jurisdiction
constitution.
to
Let me just check out
interpret.
Article 2
Mine is
quickly.
in the
But there's 138
control
as well. There's 138, not the. Okay, thank you. Excellent. So let's look at Article 2, isn't it?
2-1.
Yeah, 2 is the.
1-2-2-1.
And also the sovereignty. Sovereignty resides in the people of Ghana. We need to do that as well because the sovereignty speaks to the people who elected the MP.
Yes.
So, hey, Fatih, this is your constitution. The pages are plenty. Why?
Bring mine. It's in the.
Okay, every lawyer wants his own constitution, so let's bring his. Okay.
No, because I have.
A person who alleges that an enactment or anything contained in or done under the authority of any other enactment or an act of omission of any person is inconsistent with or in contravention of this may bring an action in the Supreme Court. Yeah, I get that, but I'm looking for the 138. I think that gives them the exclusive jurisdiction to interpret law.
Interpret the Constitution.
Interpret the Constitution. Would that not be 138?
Yes. It's a single justice of the Supreme Court. So.
Okay.
Yes.
The Supreme
No,
Court
this
should have.
is production of official documents.
All right. Get that one.
Thank you.
Get that one. Is that your constitution? It's too big.
Oh, it's that and some
Oh, we have other things in
yes,
it. Okay,
that's
viewers,
it.
sorry for all of that. Do you have time to look at that?
That would we
Okay,
have to go
so
off and come
hold
back.
it, hold it. Let's take viewers through this one.
Okay.
All right. So the Republic versus ex parte Akosa was when the Supreme Court took the decision to tell us under what circumstance do you need the Supreme Court to interpret what is the meaning of a constitutional provision, like we are struggling with the meaning of 97 and 99. Okay, so Apriku, walk us through this. So what did the court say?
So there are essentially 4 instances where the Supreme Court's exclusive original jurisdiction to interpret constitutional provisions arises. 1, where words or provisions are unclear or ambiguous. So you may have a situation where a word or a provision may not necessarily be very clear, such that upon a first reading, you can understand it. So in an instance where you seem to be confused, or people seem to be confused as regards the meaning of a word or a phrase, then there can be a referral to the Supreme Court for the purpose of interpreting that provision. Now, 2, when 2 or more rival meanings have been placed by persons on the words of any provisions of the Constitution, this speaks to Article 97, because this now becomes a question of what does remain mean?
And what does vacant?
What does vacant mean? When we say remain, does it mean the 8th Parliament? Does it mean remain simpliciter, as in you're just going to stay through the 8th to the 9th Parliament? Does it mean remain means we are ending upon the dissolution of the 8th Parliament? So those are questions that the Supreme Court will be called upon to question. The third is the conflict in meaning and effect of 2 or more articles of the court, and the question as to which of these provisions will prevail. And so these are instances where maybe one clause would say something and then another clause would say something else, and it will look like both of those clauses contradict each other. And then the fourth is a conflict between the operation of particular institutions set up by the Constitution. And we see this in beforehand, the conflict between the High Court and the Supreme Court regarding the enforcement of human rights provisions. So it is the Supreme Court that makes the determination.
So among these
That's
4
the
that
answer.
was set up in So this case has not been contradicted because it's an old case.
We still stand by it. We still use
It's still used
Yes, that is so.
as a reference point for
That is so.
when the Supreme Court is called into action.
That is
so.
so.
In the current
So-
circumstance, are we on 1, 2, 3, 4? Which one?
We are on 2, and we can even say we are also on 1.
Mm-hmm.
We are on 2, obviously. 2 is simple because the lawyers from the other side are obviously the lawyers from one side are obviously going to say that remain or vacate means that you are simply informing the person that, or the speaker, that you are running as an independent, and that automatically means that you have vacated your seat. Another side may
But
say
have they
that no.
informed the speaker? They have not informed the speaker.
Exactly. And even that,
There's no communication to the speaker
and
about anybody running independent.
and even
that
that's-
communication is going to the Electoral Commission.
and even that is the clerk that informs the electoral commission.
Yes, but there's been
So-
no communication to the speaker or the clerk's office about anybody leaving his
his
party
or her
to
political
run for
party.
another party.
Exactly.
And to remain in parliament on
Exactly.
the other party's ticket.
Exactly.
So how did the speaker know?
The
Because
question,
Haruna Idrisu said.
well, and now even that one too. The question then will come up as to what does leaving your political party specifically be? Now, loosely and generally, which may be true, declaring your intentions to run as an independent candidate.
It's an intention that you have left
It's
the
an
party.
intention that you've left the party. But for the purpose of formal and official proceedings and records, are we going to take a news publication
That's
as an official communication, as well as registration with the Electoral Commission that you want to be an independent candidate? Is the leadership of the House, the leadership of Parliament, going to take that as judicial notice to say that, okay, we have seen this
So
list?
the
or
question you are
notice of
raising is that
poll?
who makes the declaration that one has left a party?
Exactly. And it is upon
And you are bringing the
what
Mike
basis
Kokwe issue where he said the
someone
party wrote to me
So-
that this person has left the party.
So there's a reference point.
Yes. So with
So
the
I think possibly, what could have been done was the NDC, if they intended to push this through, should have written to the office of the speaker saying that the actions of filing to run as independent candidates
Suggest that
evinces an intention to leave the NPP.
Can you clarify
And then
with them?
attach a
Yeah,
notice
they-
of poll.
Yeah.
That's obviously because we publish that, okay, these are the people
Yes,
who have come to submit their names to run.
And to ask the speaker to do
and then
what?
ask the speaker to conduct an inquiry within a week.
Whether these people have left.
Whether and
so
call
that
these
letters
people-
would have gone to the political parties.
Exactly, so that we have a hearing.
Yeah.
Let the political parties, the general secretary, chairman, whoever, let them come and sit and let us have an official hearing. And then upon that official hearing, we can then make a determination and a ruling can be made that these people have indeed
I
vacated.
understand. That's very legal. But the point you are making, which I get clearly, is that a political party can have an agreement with a Cynthia Morrison.
Yes.
That because our party has had difficulties with the chieftaincy issue in Swedru, if you run on MPP tickets, you will lose.
yes.
But you are popular, so run as independent for us. We will not run. You run as independent and be the NDC. And that will mean that Cynthia Morrison has not left the MPP.
Properly so called.
Yes, and so the speaker will be wrong, and the provision of 97 will not have accrued.
Yes, but-
Because it says if they leave the party to remain, she hasn't left the party. She wants to be in parliament as MPP for this parliament, but in the next one, strategically, she's running as independent with the blessing of the party.
So that she'll come and caucus with them.
Yes.
And that is what, the reason I was saying that these are questions that, you see, these are all scenarios we are raising.
But that's the point why Mr. Bagwe's conclusions are complicated. Because one, there's no record that you have before you indicating whether somebody has left the party or not. We all have taken judicial notice of the filing and the notice of poll. But as an institution of record, like Parliament, you cannot take things on the flimsy excuse that there's a judicial notice of it. There has to be a document that has come to you, and you can write to the Electoral Commission. Please clarify whether these members of the House, who are currently members of the MPP or NDC, are filing as. Then you go to MPP. Have they left the party? If the MPP were to respond or the NDC were to respond and say no, they haven't left the party, that's where your inquiry ends. And then yes, for the purpose of what he's doing. So
exactly.
you will then begin to read things into what they did when you notice that as very seasoned lawyers, they didn't go through this procedure that you are looking at.
I also, in addition to this, I think we should learn from the United Nations.
Nations or states?
United Nations.
Okay,
the
UN.
The UN. So they have what we call the reference and advisory opinion sort of jurisdiction of the ICJ, where when there are questions like this, that are not necessarily contentious in the sense that party A hasn't sued party B, so it's not A versus B. the General Assembly can refer that matter to the ICJ to make a determination on it. So the General Assembly will say, okay, this thing.
So
we
you're
don't
looking for a
understand.
new select committee in Parliament, a committee in Parliament that's doing that, like the
Yeah,
Constitutional and Legal Affairs Committee.
We can put together rules to say that anytime there's an issue of constitutional interpretation from Parliament, let us not let the Speaker go ahead and interpret. Let us have a referral procedure that says that automatically this matter will be referred to the Supreme Court. So the case name, instead of it being called A versus B, may be called referral
Committee.
referral to Supreme Court on
So,
on the
okay,
meaning of
for a
99.
declaration by the
For a
Supreme Court.
declaration.
Oh, but
So
that's
that
allowed.
declaration
No, but
is then binding.
the 1992 Constitution already has that. If wherever you think the Supreme Court should say anything, you can go and
But
say.
the thing is that you have to go as a party.
Oh, okay. So you are creating a situation where, all right.
So that it
let's move on to the interpretation, the rules of interpretation.
So generally, the courts now have adopted what we call the purposive approach of interpretation. There is just a long way to say that we look at the purpose of the law. We do not necessarily interpret words on its face value. So we first take what the law means, the words.
So you are saying that we have to look at the ordinary meaning.
Yes.
If we can't find favor with the ordinary meaning, then we go to the purposive
The
meaning.
purpose, yes.
In going to the purposive meaning, can non-lawyers look at it and know the purpose of the thing? Do they have to think it? Do they have to guess it?
So in order to find the purpose of a provision, so many things you can use. You can use as aids to find the purpose of the provision. You can use the history, the historical analysis behind it. What you did from UK.
So the general public must have all this history before they can assess the purposive approach to interpreting the law. Let's put Article 97 now. Let's show viewers what we mean by the ordinary meaning and the purposive meaning.
So 97.
Okay, so 97 first. Yes, it says, if a member of Parliament shall vacate his seat in Parliament, if he leaves the party of which he was a member at the time of his election to Parliament to join another party or seeks to remain in Parliament. Okay, so viewers, we are saying that for the ordinary meaning of this, if we want to use the ordinary meaning of this, then it is what Speaker Bagbin is doing. That's the ordinary meaning. But what the lawyer is saying is that when you see that using the ordinary meaning takes you into absurdity, then you have to suggest to yourself that the ordinary meaning is not to be relied upon. Now, what does that mean? This is the ordinary meaning. So, assuming that 100 members of Parliament and 100 members of Parliament today have been co-opted by your party, Afrafranto. Yes, that's his favorite party. Afrafranto is his party. So if Afrafranto coordinates 100 people into their thing, and then these 100 MPs have all filed for Afrafranto, Speaker Bagbin will be asking 100 MPs to vacate their seat. That will bring Parliament to below the level where under the Constitution they can operate. So that is where you see that the Bagbin's interpretation, the ordinary meaning, takes us to complete absurdity. Absolute absurdity. Let's go to the Supreme Court.
If it's 3 months to
3 months to election, then there's no by-election.
There's no by-election.
Yes.
That means that there'll be no Parliament and no by-election.
No Parliament, no by-election.
So
How
how
will the Parliament of the Eighth Republic conclude that
How?
at a certain point 100 left?
Exactly. How will it be dissolved?
Viewers,
How will it work?
are we together? You see how ridiculous that? So this is what the lawyers themselves say, that when you take an article, you have to look at the ordinary meaning first. If you look at the ordinary meaning, it's taking you to absurdity. You have to know that the ordinary meaning is wrong. The ordinary meaning, what the words ordinary stand for. It says that if you vacate the seat, well, to the remain in Parliament thing is a bit, is another level. It's another level. So the ordinary meaning is that, hey, if you say you are going to leave the Parliament. Now, if 100 people decide that they are filing for independence, or they join Afrafranto, or they join WB Cheddar, and WB Cheddar is taking 50 and Afrafranto is taking 100 from the main parties, everybody is trying to break the duopoly. Maybe one day the duopoly will be broken, I don't know. But if we get there and this happens, is Speaker Bagbin saying that he's going to declare 150 vacant? Now, where did this ruling come from? AJ Chum, tell us.
So this
What
is
was
an
AJ Chum
example-
about?
It's an example of several other Supreme Court judgments that speak to this issue.
Yes.
So what happened in AJ Chum was that there was an issue. The Constitution laid down the procedure for how a Chief Justice can be removed. Now, if you juxtapose or if you compare that procedure to other judges of the Superior Court, so to wit, the Supreme Court, other justices of the Supreme Court, Court of Appeal and High Court, what happens is that a petition is submitted to the President, who will then refer it to the Chief Justice to decide whether or not there's a prima facie case. Prima facie case means that whether there is a, on the face of it, it makes sense that you can see that, okay, there's a case on the face of it. Now,
On the face of it means the reading of the
yeah,
document.
what should I maybe someone will say that, oh, he wants them to remove the Chief Justice because the Chief Justice wears blue too much, or he wears pink. That obviously cannot.
Okay.
Uh-huh.
So prima facie.
Prima facie. Now, the question then was, as regards the removal of the Chief Justice, there is no specific rule that's provided for that requirement of establishment of a prima facie case against the Chief Justice by the Chief Justice. So this means that if a petition is submitted to the President, the Chief Justice himself or herself was to proceed on leave
To allow the
to
president.
allow the President form a committee
To look
to
at it.
consider the petition.
Prima facie.
So in the judgment of this case, the court was asking a question that assuming that a year, the Chief Justice had 9, or the President received 9 petitions against the Chief Justice for the purpose of
Removing her.
her.
She should jump.
How will she should
So
go
she
and
should
leave
go
9
and leave them. Prima facie, she wins, then she comes back.
9
then she
times
goes
a
on.
year, really?
Aha.
So in that instance, the court said that there was a lacuna. A lacuna simply is fancy for gap, hole. So they purposively interpreted those provisions to mean that in this instance, if you want to file a petition against the Chief Justice for his removal or her removal, she would have to make a determination of a prima facie case by reading the documents and seeing that, okay, this makes sense. So the court is basically trusting the judgment of whomever the Chief Justice will be to make that determination. This basically then means that we cannot look at all provisions, because Professor Hart says something. He's a philosopher. He says that words are
Hart's
open
concept
textured.
of law.
They are open textured. The fact that a word means, even in tree, the fact that a word means something does not necessarily mean that it means that thing in all scenarios or all instances.
Okay.
So we have to look at the history. We have to even look at the consultative assembly documents in attempting to interpret that provision.
Great. So, viewers, we are fighting this on 2 legs. We are analyzing this on 2 legs. So that's what we just said. The interpretation of the Constitution, the rules of interpretation, which is used by all courts all over the world, is that you just have look at the ordinary meaning. If the ordinary meaning is creating an absurdity, then you go to the purposive meaning. And that's the journey that I was asking Apreku, that how do ordinary people decide on beginning the journey to look at the matter in its purposive approach? So, purposive approach just means that you don't have to interpret the thing to take away the purpose of it. And you will see that you are taking away the purpose when your interpretation is pushing to ridiculous levels. So that if, as we were saying, 150 members file for independence, Speaker Bagwin says all of them should go. You can't say that there's no possibility of that happening in a social science situation. That's why we always say all things being equal. All things will not always be equal. So sometimes things are not equal. If that happens, it's a novel situation, it's surprising, it's shocking, it couldn't have been predicted, but it can happen, isn't it? The same way Speaker Bagwin is sitting on the chair when the majority who should have voted for another candidate didn't vote for him and some voted for him, 2 of them, etc., etc. That happens. So if you look at the interpretation, the point we are making here is that Speaker Bagwin is wrong, because even if you look at the rules of interpretation, first of all, he's wrong because the Constitution did not give him the power to determine which seat is vacant when there's a conflict. The Constitution clearly gave that power to the High Court in Article 99. It's very obvious that they gave the power to the High Court. And it says also, in terms of informing the Electoral Commission, that when a vacancy has occurred, can you find that provision? When a vacancy has occurred, the Speaker will inform the clerk. So the law says when a vacancy has occurred. So it means that the vacancy occurring, the Speaker doesn't have a role to play in it. It says when a vacancy has occurred, the Speaker will inform. So the vacancy occurring is clearly given to Article 99 and is given to the High Court, that the High Court shall have jurisdiction. Can you read
The
it?
vacancy occurring is Article 112 clause 5.
Yeah.
Whenever a vacancy occurs in Parliament, the clerk to Parliament shall notify the Electoral Commission in writing within 7 days after the vacancy occurred, and the by-election shall be held within 30 days after the vacancy.
It didn't say when the Speaker declares a vacancy. It's when a vacancy occurs.
Yes, exactly.
When does a vacancy occur? They've already told us when a member of Parliament decides to do that. If he doesn't go and tell the Speaker together with his party that on the basis of that a vacancy has occurred, then Article 99 says that the High Court is the one who will determine whether a person has been validly elected. They would also determine whether a seat has become vacant or not. So that's one leg on which we are dealing with it. That the Speaker doesn't have power to do so. It is the High Court that has power to do so in case of a dispute. So forget about that. What about the Supreme Court? The Supreme Court has a right to come into the matter because the minority leader sued and was asking for the Supreme Court under Article 2 to make an interpretation,
130.
under Article 2 and Article 130, to make a determination of a clause. So that's how the Supreme Court is in. But originally, Speaker Bagwin doesn't have the jurisdiction as it would appear from the document. Okay, so the absurdity rule is the first leg of the first leg is the Article 99. He doesn't have power. The High Court that. The second one is even as he tries to assert the power, his interpretation is taking us to absurdity if we were to keep with the ordinary meaning of the provisions of the law as explained under the 1992 Constitution. Is there anything you want to add to the rules of interpretation? I go to DF Anand.
No, that's a separate.
Now, you want to add something?
I would have to rush to the back. So
Okay, to get it from me. Okay, so okay, yes. So you're excused. He's leaving. He's leaving. You can't see him, but he's gone. All right. Now, this is all very interesting. So I think that we've come to the conclusion. I hope that is rounded well. Two things. Speaker Bagwin, under Article 99, may not have been the right person to declare the seat vacant if there was a conflict. The Supreme Court is entitled to come in based on ex parte accosa, where the Supreme Court laid out the 4 instances on which the Supreme Court will always come in. Of course, it is grounded in Article 2 of the 1992 Constitution, the current Constitution. Ex parte accosa was held under the 79 Constitution. But this 1992 Constitution, where it's clear that the Supreme Court have power to come in, but the High Court is the one that was given the power in the Bagwin situation for them to be able to say whether a seat is vacant or not. And in any case, if the High Court were to say that, one can still go to the Supreme Court to challenge the High Court's decision, and that's settled. But the Speaker's interpretation is bizarre. Now, we are hearing tonight that Suedru Nana, is that her name again? Yes, Suedru MP, and the Suhum MP, Cynthia Morrison, and the Suhum MP. The two of them are saying that they have not left the MPP. So what's Speaker Bagwin going to do? This is the ridiculousness of these things that happens. The two of them are saying that, oh, we were thinking about it, but their photographs are online tonight where they are having photographs with Afenyo Makin and Kennedy Japan, and they are talking to them. So they come back to Parliament on Monday and said, oh, Mr. Speaker, we are changing our mind, though. We are not going anywhere. And then Afenyo Makin will go and withdraw his writ for the Supreme Court that the writ is now moot because the persons that have been mentioned, 2 of them, say that they are still with the MPP. What then is NDC going to do? Let us get politicians who are more serious, okay? But let me get you to the story. And again, why I think that Speaker Bagwin has failed the test of patriotism. This was an important matter in which the Speaker could have settled things in a way that will not potentially create a problem for Ghana. If the MPP had reacted to what happened in the NDC, what the NDC did in Parliament this morning, the potential chaos would have erupted. The Speaker himself called for police and soldiers to come to Parliament this morning. Why did he have to take himself into that situation? It was completely unnecessary. For a Speaker who is a very seasoned barrister, he really should have known what to do. And I'm going to show you, when I say he should have known what to do, what another Speaker did, Justice D.F. Anand. So what happened in the Justice D.F. Anand case? One morning, during the second Parliament of the Fourth Republic, Flight Lieutenant Rawlings, what are they asking me to do? Yeah, I have a break. Okay. So don't want me to take the break? I'll take the break after. Don't worry. I'll take the break after. Sorry, viewers. Sorry about that. When the momentum is there, I don't want to stop. Okay. So one morning, the Parliament started work, and then J.H. Mensah, the minority leader at the time, heard that the president, Flight Lieutenant Rawlings, has sent a list to Justice D.F. Anand for the persons to be considered under Article 78 with the prior approval of Parliament to be nominated as ministers. J.H. Mensah was aware that the prior approval of Parliament means that these persons must be submitted to the Appointments Committee for hearing at a vetting situation. The J.H. Mensah had also heard that the majority in Parliament were describing the situation and saying that there was no need for these members to go to vetting because they had already been vetted by a separate Parliament. The first Parliament of the Fourth Republic had vetted some of them. The NDC members were saying that only those who were not ministers in the first Parliament should be submitted to vetting. This is the matter of the matter that was going on in Parliament at the time. Speaker D.F. Anand, you know, is a member of the PNDC, he's a CADA, he's all that. And so J.H. Mensah then looks at the matter and says, I'm going to the Supreme Court. So he files a writ at the Supreme Court and says, Supreme Court, the Parliament of Ghana is preparing to take ministers from the president without taking them through vetting, and they are calling them retained ministers. I think that according to the law, they are wrong. So he's inviting the Supreme Court to make a declaration, so and so and so and so. Okay. Whilst his writ is pending at the Supreme Court, he goes to Parliament one morning, and Richard Kwame Pepra, the former finance minister in the First Republic, in the first Parliament of the Fourth Republic, is now coming into the second Parliament without vetting to deliver the budgets of the government. J.H. Mensah is worried, so he writes a letter to the Speaker as follows. Okay. He writes a letter to the Speaker as follows. Mr. Speaker, appointment of ministers. Article 78(1) of the Constitution. With reference to the President's letter to you of 10th February 1997 and the various consultations that have taken place on the issue of the appointment of ministers, I will be very grateful if you would confirm that in submitting the names listed in the first paragraph of this letter as members of his new cabinet, the President was inviting Parliament to exercise its power of prior approval of their appointment as ministers. I am seeking this confirmation in order to be assured that no action in Parliament is taken which in any way prejudices the determination of the constitutional issues raised in my writ, of which you have notice. I will be grateful for an urgent response to this letter. Yours sincerely, J.H. Mensah, Minority Leader. So this was the circumstances. Kwame Pepra has arrived in Parliament. Kwame Pepra is coming to read the budget. J.H. Mensah is telling Speaker that my writ at the Supreme Court, which you know about, it suggests that the Speaker was not sued in the thing. It's Parliament that was sued. So J.H. Mensah is saying that my writ, which you may not have been served, but you surely have notice of, is going to be prejudiced if you proceed to allow Kwame Pepra to read the budget. This was how high the stakes were. This is the government's budget. The government has an overwhelming majority in the House. The government has nearly 2/3 of the people in the House. They are only short of 2/3 by a few. That's the government size of the Parliament. The Speaker is a government speaker. Kwame Pepra is the government's minister. He's coming to read a budget. J.J. Rawlings is the military strong man who has won a second election. Everything is riding for the NDC. But here is a speaker who was patriotic. Here is a speaker who was thinking about the nation. Here is Justice D.F. Annan, having spent many years of his life as a justice of the Court of Appeal, having spent many years of his life observing the democracy of Ghana. Who wants Ghana to succeed? He wants the Fourth Republic to succeed. He wants the institutions of the Fourth Republic to succeed. So in spite of the fact that they can bully the minority all they want, they can tell the minority you can go to court and we don't care. Watch J.H. Mensah's response. Watch D.F. Annan's response to J.H. Mensah. Have a look. Okay, D.F. Annan response. Honorable J.H. Mensah, Minority Leader, dear Sir, appointment of ministers, Article 78 of the Constitution. He says, I acknowledge the receipt of your letter. The receipt of your letter, reference number so and so, dated 13th February on the appointment of ministers, Article 78(1) of the Constitution. My reading of the express words of the letter from the President's office leads me to the view that all the names of the persons proposed, whether they are retained ministers or newly nominated ministers, were submitted to the House for the purposes of discharging the House's constitutional responsibilities in relation to the approval of ministers. Full stop. So D.F. Annan is agreeing with him that yes, the President's letter said that we should discharge our responsibility with ministers. But he was already hinting, J.H. Mensah, that maybe you won't get the vetting that you are looking for because the processes, now let's read on. It says, the processes and procedures leading to approval or rejection of ministers remain entirely within the competence and the authority of the House. That's what J.H. Mensah is saying. How we do the ministers, how we approve them, remains in the House. But listen to what D.F. Annan says. He says, and this is the most important, and this is what I thought Alban Bagbin would have looked at, the current speaker, because the current speaker was a member of the House of this Parliament. He was a member of the second Parliament, and he was there when this happened. I don't know whether he's mindful and has notice of this letter, or it's just in my book I can share with him. This is what D.F. Annan says. He says, I agree that no action may be taken in Parliament which in terms of our standing orders prejudices the determination of the constitutional issues raised in your writ, which is now pending before the Supreme Court. Look at it again. He says, I agree that no action may be taken in Parliament which in terms of our standing orders prejudices the determination of the constitutional issues raised in your writ in Parliament. In effect of this, D.F. Annan cancelled the budget presentation by Richard Kwame Pepra. You got to clap for that guy. D.F. Annan cancelled it. This is a speaker who had an overwhelming majority with him, who had J.J. Rawlings with a gun at the castle, who had the NDC in an election victory of 57%. And he is able to talk to the minority leader at the time when there was a lot of bad blood between MPP leaders and J.J. Rawlings. D.F. Annan took out his pen and wrote this and told Parliament that because we do not want to prejudice the constitutional issues raised in J.H. Mensah's writ, Richard Kwame Pepra cannot present the budget to Parliament. What would it have cost Mr. Bagbin if he had said that I have an interpretation of this matter, but in order not to prejudice the constitutional issues raised in the majority leader's writ, of which I have noticed, I will hold on and wait for the Supreme Court to give us an interpretation of this matter. That's what D.F. Annan did. He said, I agree with you that we shouldn't take any action to prejudice the outcome of the Supreme Court's ruling in the constitutional issues that we have raised. On the basis of that, he said Richard Kwame Pepra cannot present the budget. The budget was presented another time, but on that day, Justice D.F. Annan, these are the legends of our democracy. These people, they are the legends of our democracy. Justice D.F. Annan, Peter Adjete, Nana Akufo-Addo, Dubois, Koshigan. These are the legends of our democracy. These men, they are the legends of our democracy. So let's learn from the history. Let's not bastardize the history. Let's not be joking with our democracy. Let important people not be joking as if they are doing koliko. No, we are serious people. Let not Parliament be joking and go to the Parliament and be joking. Please play that video again. The one, get it ready. The one that we started with when our friends in the NDC were in Parliament this morning. Get that video ready. Let's stop that. As young people, demand more of them. Demand it from them. Demand it. Demand it. That we need high standards. Why are you boycotting Parliament? Why are you saying that you have majority? Explain to me. Why are you doing that? What about the campaign? Where are the issues? What are you telling us about water? What are you telling us about electricity? What are you telling us about education? What are you telling us about transport? These are the issues that matter to the Ghanaian people. It's not people who are trying to gymnast so that they can have majority in 72 hours and the majority is whittled away by a Supreme Court decision. We can't do that. Not these people who come and take us on a wild goose chase that the Electoral Commission has a wrong register and that there's something is going to happen and Ghana is going to ban. And then they are asked to provide evidence and they say they have none. It's not these people who are waiting for the TUC to go on a rally and or TUC to go on a national lockdown before they have a campaign message. We can't have politicians like that. We must have politicians who are above that level. As is D.F. Annan, rest in peace, you go to heaven. What are people saying on the text message before we take the break? All right, let's take the break first. Let's take the break first and then we come back. Let's take the break. Are we ready with the break? What are they saying? Okay, all right, okay. Yeah, okay, Fatih.
All right, thank you, Paul. So this is coming from Pa Kofi, and Pa Kofi says the NDC has always let the nation down when it comes to upholding the constitution in any manner concerning the nation Ghana. William Danchi says, typically, NDC politician Bagbin is just playing mischief to frustrate the government for the NDC to have political advantage coming December. He has an agenda. He has been reckless from day one and has failed woefully. Now, Safui Fambali says, good evening, Mr. Paul. The NDC minority's action can be described as those of intellectual or narcissistic intellectuals. Thankfully, Mr. Speaker demonstrated wisdom by adjourning the sitting indefinitely, and which is merely a defensive strategy. Now, Nana also says, if you play for Arsenal and have been bought by Manchester United to play for the next season, does that mean that you have to stop playing for Arsenal because you'll be playing for the new team next season? This is a matter of intent based on the duration of your contract terms. Bernard Dancer says, Paul, I appreciate the insights you gave and your co-analysts are giving us tonight. However, I would rather we had not gotten here in the first place if Cynthia Morrison and Kwejo Asante had accepted their defeat honorably in the primaries. They should bow their head in shame. Samuel Fosuba says, NDC fraternity don't read to deduce the basic intent of the publication. Instead of them to read to acquire wisdom and knowledge, they rather read for fluency. That's why they rattle during speaking. NDC and shabby work. This leads them always causing commotion and brawling, whilst the NPPs are doing brain exercise. Lastly, William Dante says, Speaker Bagman has already done enough damage to the current dispensation. Thank God he will soon be history, but he shouldn't plunge the nation into chaos before he leaves. Enough of this. What do you have for us?
Fati. From Baba Sherman Tamale. Indeed, the NDC always wants to achieve any and everything with violence, but like the majority leader said, the NPP will use their brains to achieve what they desire. From Bizi Nana Kwame. The NDC is frustrated about the defeat that awaits them as Dr. Mahamudu Bahumia is miraculously turning the tables in all their strongholds. From Ni Okine Kaswa. The NDCs want to find every means possible to make this government unpopular, but the NPP will not fall for this trap. It is possible with God. From Clifford K. Bafour. If all Ghanaians decide to behave like the NDC, there will be fire in this country for no reason. Such an empty option. What do you have for us on Sunday?
Yes, so we still have people trying to explain the article. In the likes of Jawad Mustafa, he says, Paul, I think there is no ambiguity in the article actually. If the member defects from his original party to another party and seeks to sit with his new party in parliament, then that is prohibited by the law. But if the member defects and does not seek to sit in parliament with his new party, I think that can be allowed because both the original party and on whose ticket the member was elected to parliament and the defected member were in agreement to work together in parliament until the end of the parliament section. Now, Nixon Nation says, notice of polls is not enough grounds for anyone to juxtapose that one has left the party and so warrant his or her removal from parliament. That's what he thinks. And he says, if an MP is removed on the grounds of illogical provision like this, how are their constituents compensated so their representation is not affected anyways? And if there is no provision after their removal, wouldn't it affect their constituencies? Must a constituency be there without representation? He asks. The NDC should allow the laws of the land to work and stop this McCoyism. Nana also says that the buzzword is intent. The NDC party has shown the country that they don't like reading. Ghana runs a constitutional democracy and not a parliamentary one. The NDC should remember that elections are won at the polling stations and not on the floor of parliament. Now, Shadrach Imbalem says Haruna Idrisu actually did that. He wrote to the Speaker of Parliament and he demanded that he will be pronounced his seat vacant. Jeffrey L. Jeff thinks that you cannot be an independent candidate and still be a member of parliament. Clem Badwell says, Paul, you actually are making a good point, but I think you are not explaining it coherently. My understanding of what you're saying is that the subject matter of those MPs' decision to go independent is with the 9th Parliament and not the 8th Parliament, or otherwise the current Parliament, and therefore they cannot be asked to vacate their seats in the name of cross-carpeting. Is that not so, Mr. Paul? Now, Fred A. Yancer says, are you actually aware that by the constitution of the party they represent, which is the NPP constitution, they cease to be members automatically if they stand as independent candidates of the party that sponsored them and against another party, another member of the party? They cannot also hold themselves as members of NPP in time now. Bennett Allen says, hello, Paul. The NDC is fully aware of Article 97. They are just attempting to mislead the Ghanaian public, but their actions have completely been exposed. And lastly, Nana JB Edusei also is here with an interpretation of his own. He says, Paul, I think almost everybody is misinterpreting the Constitution. What the Constitution is saying is not a member seeking to stand independent in the next parliament, but rather cross-carpeting to the opposite side in the current parliament in which the member was voted to serve in. In this case, the said members are still with the parties on which ticket they came to power with. I'm very surprised that even professors are getting this wrong. Now back to you, Paul.
All right. Okay. Are we back on DSTV now? Do you know? Can you check? Okay, so I think there are a couple of questions in the text messages that we may have to explain the other day. So as we explain again. So we're saying that Speaker Bagman's decision is interesting because the people, if you look at that constitutional article, the people are not asking to shift from. Cynthia Morrison is not saying that she's going to be an independent member of parliament now, that her seat is to be called as an independent member of parliament. No, her seat is still MPP. So as far as this parliament is concerned, she's not changing anything. Whatever she's discussing with the Electoral Commission is for the parliament of the future, of which Speaker Bagman has absolutely no jurisdiction. That's really the first point we're making, that when the law says when the person moves and seeks to remain in the parliament, none of them is trying to remain in this parliament. It's not possible to remain in this parliament with your seat now, which was MPP, now to be counted as NDC. So they can't do that. That's not what they are doing. What they have done by filing a nomination is for the next parliament. It's not for this parliament. That's really the point we're saying. That's a big part of the conversation. The next level of the conversation is that, therefore, that even if the seat were to be declared vacant, the Constitution says the High Court shall have the power to do so. It's not the Speaker. Then the Supreme Court has power to interpret all clauses of the 1992 Constitution and to impose their interpretation on any institution or authority under the 1992 Constitution. So this is, in a nutshell, fundamentally what we are saying about the Bagman thing. Maybe if I have to say it again. In a nutshell, we are saying three things. First one, that the clause, Article 97, says if the people are shifting, wanting to remain in this parliament, all of them are not seeking to remain in this parliament. Second, Deputy Speaker is seeking to remain as independent in this parliament. That's how he came. In the next parliament, he wants to join MPP. Cynthia Morrison is seeking to remain in this parliament as MPP. That's how she came. She's not changing that. In the next parliament, she wants to be independent. The member of parliament for Suhum wants to remain member of parliament for Suhum for this parliament. In the next parliament, he wants to be independent. Now, NDC guy for Secretary wants to be NDC for this parliament. In the next parliament, he wants to be independent. That next parliament, for which they are filing nominations now, is only administrative. Administrative because they have to file it now. What they are filing now has nothing to do with the role that they occupy in parliament today, or the side that they sit in parliament today. It has nothing to do with that. Speaker Bagman has supervisory jurisdiction over the 8th parliament. He doesn't have anything over the 9th parliament. So if a parliamentarian says that in the next 2 parliaments, I want to join NDC, I want to join independent, that's not why you take him out of this parliament. That's the first leg. The second leg is that even if a seat is vacant or there's conflict about whether a seat is vacant or not, the Constitution clearly says it is the right of Article 99, and that shows that the High Court has the power to do so. But the Supreme Court also has the power to do what it did because the Supreme Court has jurisdiction in Article 2 and Article 130. They have total jurisdiction. That's the conclusion of everything that we have said on the touch screen today. I hope you get it. It's 10 past 11. Thanks for watching. Good night.